Hello, Judge French. We do see you. Just so you know, you're connected.
Thank you very much.
And here, so we're going to talk about just a couple things, and let you kind of segue into whatever we say that's wrong or right about the new PMO. Good morning, Angela.
Good morning.
All right. Good morning, everyone. And welcome to our July 27th, 2020 version of Bar Talk. And we do have a special guest, Chief Judge Jed French, that's joining us today. And what I wanted to do is just sort of start off our process a little bit by a couple of reminders of where we currently are at and what's new since we last met last week. So just taking a look at what's on the governor's website, just to remind everyone, we are still in a civil state of emergency until August 7th. We haven't seen any changes on that. We did recently get a new PMO SJC6, which was revised and issued on July 23rd regarding forcible entry and detainer cases. And remember, when we had Chief Meade on 2 weeks ago, he had mentioned that he had alluded to there being a CARES Act issue related to forcible entry and detainer, to evictions, when it involved government funds in some way. And he has assigned this new PMO related to what we have to do as attorneys on eviction cases. And in particular, I just wanted to highlight what caught my eye. The PMO is just 2 pages, and the summary of what needs to happen is on the 2nd page. But what has to happen now with every complaint for eviction, we need to now include a multi-page form that verifies if this complaint is before August 31st, 2020. We've got a multi-page form, 3 pages, to verify that the eviction is compliant with the CARES Act. And for any cases that started or that were filed between March 18th and into the future until August 31st, 2020, we need to file this form also. So in other words, if you've already filed an FED from March 18th, you need to supplement your filing with this CARES Act form. That's my read of it, and I wanted to share that with you all. We do have Judge French with us, and Judge French, I'm sure, could supplement or add anything that he would like onto our interpretation of PMO SJC6. And Judge French, you're on mute still. Just want to make sure you knew. And that we're very happy to have you on. I know that I believe you actually just became the chief trial judge. Was it during the COVID pandemic?
I became the chief April 3rd, which was right as we started to really decide how we were going to handle things in the judicial branch with the onset of the pandemic.
Well, I appreciate you joining us today, and I did send you kind of a litany of things that we wanted to kind of hear about from the district court's perspective, and I'm hoping you might be able to kind of update us, and we'll if there's a time you want us to ask questions, we can do that then too. But I appreciate you being on, and the floor is yours.
I'm happy to have, thank you. I appreciate you asking me to join you today, and I'm glad that I have the opportunity to do that. I'm happy to have questions at any time. Unfortunately, as you probably have already heard from Justice Mead on a number of occasions, there are more questions than we have answers, because this really is very dynamic as we try to work through all the issues that we have, and for every solution to a problem that arises, other problems then arise, and we deal with those as quickly as we can. But I wanted to back up and talk about a non-pandemic related thing just for a moment, because I'm not sure everyone understands the way scheduling works in the main judicial branch. And so I just wanted to go over that just briefly. I know it was on the suggested agenda to talk about that, but we divide the state, the judicial branch, into 8 regions. And those 8 regions don't necessarily coincide with the statutory districts, don't necessarily coincide with counties. There are some regions that have multiple counties. So I just want to tell you what those regions are. And the reason I want to tell you about the regions is because you asked me, Attorney Day, to talk briefly about some changes to some judge assignment within those regions. So it'll make more sense once I do that. So just briefly, Region 1 is York County. Region 2 is Cumberland County, which includes Bridgeton. Region 3 is Franklin, Oxford, and Androscoggin County. Region 4 is Somerset and Kennebec County. Region 5 is Penobscot and Piscataquis County. Region 6 is Waldo, Knox, Lincoln, and Saginaw County. Region 7 is Hancock and Washington County. And Region 8 is D County, Aroostook County. And the district court judges that we have get assigned, as you know, they can sit anywhere within the state, there's no limitation, but for purposes of scheduling, we generally assign them to regions. Some judges sit in more than one region, and it all depends on the resources that we have available, whether they're assigned to more than one region or to a particular region. Sometimes, because of these limitations of resources or because of the needs associated with different regions and what dockets they're hearing or not hearing, or whether or not judges are retiring or have taken vacation, judges get assigned to a different region where they have been sitting in the past. So in June, we decided, or I decided, that some judges would be assigned to a different region from which they've been sitting. So you as lawyers may see different judges in courts that you were accustomed to seeing them. So Judge Martin was assigned to Region 6. Judge Archer was assigned to Region 3. Judge Montgomery was assigned to Region 3. Judge Rushlow used to be in between regions, but he'll be primarily in Region 4. Judge Davis is going to Region 4, and Judge Walker will be going to Region 6. So those are some of the changes that you asked me, Attorney Day, to talk about, so I wanted to bring those up with you. So that's kind of how the scheduling goes. And then as far as the scheduling of judges, within each region, we have a district court and a superior court regional scheduling judge. And those regional judges get together with the clerk of each court, and they sit down, and it used to be on a quarterly or every 2-quarter basis, and come up with a schedule, which then got published to the internet so that litigants and attorneys could see what the schedule was. During the pandemic and the limitation of the pandemic, we sometimes are doing schedules on a day-by-day or week-by-week basis. And with the implementation of the phase management plan, the idea was we could hopefully get away from that day-to-day or week-to-week scheduling into something more long-term. And we've had some success at that, and we've also had some limitations, judicial resource limitations, which have prevented us necessarily moving through those steps as quickly, those phases as quickly as we'd like to, or the way it was anticipated. So phase 3, we started July 6th, and phase 3 was essentially allowing every case type except for FEDs, disclosures, foreclosures, small claims, and violations bureau. We started grand jury in most regions, I believe, or most counties. We got to family matters, and mediation has started. If lawyers haven't got final hearings yet in FM cases, they should expect to get those soon. The magistrates have been very busy. So that phase went off pretty well. We continue to focus on those cases that are priority cases as set forth by the SJC. And now we're getting ready for phase 4, which brought us to PMO SJC6. So phase 4 allows for some changes, again, provided the resources exist, which essentially allow for any of the proceedings which were prohibited prior to this time. And I'll be clear with you that the only one of those proceedings that I just said couldn't happen in phase 3, so FEDs, disclosures, foreclosures, small claims and violations, the only ones that we're planning for in the month of August, as we speak at this moment, is FEDs, and which, by the way, includes personal property. So FEDs are the only ones being planned at the moment. Having said that, we put together a committee to look at the ability to get these matters heard back in court. They're actually meeting today, again at noontime. So we should have some final answers with regard to small claims and disclosures. My expectation is that they'll not be heard in August, but that more to follow on that. With regard to FEDs and PMO SJC6, as you probably saw, the first focus will be on those cases that have already been filed. So a number of cases were filed prior to the pandemic, and those were all continued generally. And then cases were also filed during the pandemic. So those cases that were filed and had been filed prior are being scheduled for case management conferences that'll be held by telephone, and those are going to be sent out by the clerk. And it's at that first conference, or prior to that first conference, that a landlord and or a landlord's attorney will have to provide the verification that they've complied with the CARES Act. Again, after the noontime meeting today, we hope to have more answers about how we're going to go forward with those cases that will be filed after the beginning of the next phase.
Now, Judge French, before you go on, I just wanted to clarify something. So the PMO tells everyone that has an FED action to file this new form, even if it was filed, back in March or from March 18th forward. Are the clerks going to be waiting for that form before they schedule a telephonic conference?
I believe the answer is no. They're going to schedule the telephonic conference, but the verification form has to be to the court prior to the conference. And thanks for the clarification, by the way, because the verification form would not be necessary for those cases that had been filed prior to March 18th or whatever day the CARES Act took effect. It would only be for those that were filed after.
Thank you.
So there was a question I saw that came in regarding why some judges are scheduling family cases, case management conferences in person rather than by telephone, giving the comments by the SJC that they're strongly preferred to be done by telephone and or by video. And the answer is that it's clear that that is the mandate from the SJC, that the preference is to do those cases by video or by telephone. And the availability of those resources is limited in some respects. And there was actually a question, I think, about Zoom and Zoom hearings. I have a half update on that, which is that the judicial branch has arranged for each judge to have a Zoom license, and shortly, that the process has not yet been finalized, but shortly each judge will have access to Zoom. So we will have that resource available very soon, which will help with the availability of telephonic and video conferences. To answer the question specifically, each judge has the discretion to make those decisions, and there may be a reason why the judicial officer has decided to do that in person. It doesn't mean that a judge or litigant should not contact the judicial officer by motion prior to that time to inquire whether or not they can participate by video or telephone, and that is always welcome.
Judge French, this is Angela Armstrong. I have another question that was related to something you were talking about. And also have the closed caption available.
So I'm sorry, Angela, I couldn't hear you. You were breaking up. I'm not sure anyone else was able to hear or not.
Okay. Let me put it on the chat.
Okay.
And Judge French, while Angela's putting that on chat, we also, I believe there was also the topic of CASA that you wanted to touch base on too. I wanted to make sure we didn't lose track of that with the time we've got.
Thank you. So with regard to small claims matters, again, there'll be some determination made about whether or not we're going to go forward in August about that. If the decision is made that we're not going to go forward in August, which doesn't mean we won't in September or October, but in August, still litigants or lawyers have the opportunity to file a motion with the court and explain why the circumstances are such that they should go forward. So they still have that option to do that. There was a question about whether or not the Zoom has the capability of closed captioning. I don't know the answer to that. I'll bring that up with our OIT folks and get the answer, and I'll let Attorney Day know what the answer to that question is so you can distribute that to the Bar Association.
Thank you.
What I wanted to talk with about CASA was just to let everybody know that we're going for, we've had a couple, the family division has had a couple training since the pandemic, or during the pandemic, I should say, that we've done virtually. One was GAL training, which occurred last month. We're going forward with CASA training, and that's going to happen August 11th through the 14th. And that will all be done remotely or virtually. And we currently have 24 participants that have signed up for that CASA training. So that'll be a big boon and help for child protective matters. So I just wanted to let folks know, if they had any questions, they can go to the website or contact the family division about that.
Thank you, Judge French. I'm just taking a look at our time, and I want to be cognizant of it. In particular, Chief Meade said that there were like 400 licenses that were being obtained by the judicial branch for Zoom. Does that sound right for you?
I heard the number from him as well. I think that sounds right.
So it sounded like you were talking about a Zoom license being available to each judge. What would be the purpose for and the use of all those licenses?
So the expectation is that most, if not all, conferences of any kind that don't need to be recorded for the record will be done by Zoom. So every judicial officer would need to have a license to do that. For those matters that require a recording, we're still going to be using our FTR, which is for the record, is the name of the device that does that. We're still going to have FTR recording, which will happen with a clerk ensuring that that happens. So for every courtroom and every clerk that does FTR recordings, they will also need to have a license to ensure that that happens.
So the intention is not to use Zoom for recordings then?
That's my understanding. That's right. And this is all, as you know, very brand new to us. Many states have done or used Zoom even prior to the pandemic for these kinds of things, and we're working through those processes to make sure that we can meet the needs, again, the resource needs of the branch, as well as ensuring that we can ensure the due process rights and requirements that everybody has.
Okay.
There's a second question. Do you see it, Thad?
I don't, but you can go ahead, Angela. What? I can't see it.
You can hear me?
I can. You sound good.
Does the district court have any suggestions on when municipal practitioners should begin filing Rule 80K land use violation cases, particularly as they require an initial appearance hearing?
I don't know the answer to that. But that's also something that wasn't specifically addressed in any of the PMOs or in the phase management plan. My expectation is that we'll know more about that shortly. If you look at the priority of cases, I don't believe this falls within one of the priorities. And as we focus solely on trying to get those priority cases resolved, those cases that don't meet the priority standard will be pushed farther and farther back. But I'll try to get an answer to that question as well.
And then someone wrote in and said his understanding is that the PMO 6 only deals with eviction-related FEDs. Unless he misunderstood it, he's not sure if the courts will hear personal property FEDs as opposed to eviction-related FEDs prior to phase 4.
So right now, when we talk about FEDs that were either previously filed or have been filed during the pandemic, they will be made part of this PMO SJC 6. So they'll be scheduled for a conference. As far as newly filed FEDs, whether it be for personal property and or evictions, we'll have an answer to that shortly. Again, they're meeting today at noon to talk about how to go forward with those matters.
Judge French, while I have a chance and opportunity to ask this, have you been getting any feedback at all about the availability of mediators, whether it be for a family law case or otherwise, through the court system? They're, just through some personal experience and through some other attorneys that have brought it up with me, there's been orders by either a magistrate or a judge saying, hey, the next step is mediation, but we're still holding on for that mediation to happen.
Yeah, the cadres, which is the committee dealing with alternative dispute resolution, is very active, and they are conducting mediations right now. And all those mediations are being done remotely or virtually. And the mediators that are participating in those have to ensure that they have the capabilities of doing so. And that's not something that the judicial branch is able to provide them technical support with necessarily. The other thing is that the process for that now has, and I'm sorry, I don't know for certain, but a number of additional steps that wasn't previously required. So after mediation is ordered, a magistrate then needs to mark any of the filings that need to be provided to the mediator. That file then needs to go to the clerk, who needs to get those filings to the mediator. The mediator then needs to check their schedule and get the information for how the litigants will participate, whether it's through a telephone number and or a Zoom link, for example. So probably one of the reasons it's being delayed is because of all those steps that didn't previously exist. Similarly, the length of time it's taking to accomplish all of these things virtually, I think, is greater than what people expected. And those that are using it as we are now, and this is only a handful of times I've used Zoom. Prior to this time, we've had to use Google Meet. It takes a while to kind of teach yourself as you go along how to ensure that you understand the capabilities of each of these programs. So mediations are happening, they're being scheduled. I expect that they will continue to be, and hopefully we'll see more of those.
And I did want to mention too, District 6, I had one of those special mediations with, and it went great and went fast. District 2 has actually been the one that's kind of slow in scheduling those things. So it's, I'm sure, a resource. I just wasn't sure if you had heard anything specific about it. That's all.
I didn't, but I appreciate the input as well, because that's information that I can look into that. I do see a question from on the chat about a family matter docket being in person in Augusta. In the past, folks have called in on a conference line. Was there a plan to resume the ability to call in for the docket call? Again, it depends. It's really a judge by judge decision, even though the preference is clear what it should be. And any attorney or litigant that would prefer not to participate in person when they've been asked to participate in person should certainly file something with the court to ask to be allowed to participate remotely. With the advent of Zoom and the ability to have, and I forget what they call them, breakout rooms, is that what, or waiting rooms, which we didn't have with Google Meet, that's going to give a lot more opportunity than we've had before. So my guess is that once we have Zoom deployed to each of the judges, that you'll see many more of these things being done remotely and not in person.
So with the Zoom accounts right now, if you have the free version, you can have, if you have more than 3 people on a call, it stops you at like 40 minutes or 45 minutes. Will the mediators have to purchase accounts for themselves, or?
My understanding is that they have. I don't know that for certain, and I haven't confirmed that, but I've heard from other folks that they have in fact done that.
On their cost of business, I guess, at this point.
But I have not, I've just heard it from other folks. I haven't heard it from a mediator or from Diane Kenty.
Now, Judge French, I see Barry Kohler has offered up some information from Cadres. I did just want to mention that one of the things that before, if you decide we'd like to have him speak on that, we can do that. But we've talked about backlog for small claims, which you basically have said that it probably won't start to be scheduled until after August. We talked about backup for FEDs and how the backlog's going to be heard, but we really haven't addressed like the other types of backlogs, like family cases that are sitting in backlog, and civil cases that might be sitting in backlog, and what the approach is from your perspective, whether or not you're delegating that to be district by district, or how you're going to handle that.
Yeah, I would like to hear from Barry Kohler, but I'll answer your question first. So it is region by region to some extent, and it all depends on what their judicial resources are. Civil is one of those cases similar to Violations Bureau and similar to disclosures that are not priority cases. The family cases are priority cases, and we're working diligently to ensure that we have the resources to address those. And actually, I think I've heard from different regions that they're making pretty good progress. The difficulty is that in some regions, for example, they might only have 3 or 4 FED cases that need to be scheduled each day, or 1 day per week for 4 weeks to get caught up with the backlog, while others may require weeks and weeks of that. And so those cases that have the smaller dockets are able to squeeze in, for example, family cases on the same day that they have FED dockets. So again, it's really a region by region, court by court basis. But those priority cases are being focused on. And for those that are involved in family law cases, I hope that you're seeing some movement on that, because I know that the magistrates and judges that are handling those cases have been really, really busy.
Thank you. Is Barry still on the line? If he can add some points on what Cadres is doing, that would be good.
Sure, I'm happy to do that. So, so the Cadres Committee takes seriously the backlog that's developed, and it's very different region by region and court by court. One of the problems is getting the mediators sufficiently trained on Zoom in particular, and also for the telephone mediation model, takes some time. So that not all of the mediators that were doing family matters before have indicated a desire or transition to doing family matters via Zoom or telephone. The backlog in the courts is different. Portland, Cumberland County has a ton of cases. The smaller courts and the more rural courts are able to sort of better handle it. And I think my impression is that the clerks are using different strategies in each court. The latest thing that the Cadres Committee has done is figured out a model for how to do Zoom mediations in FEDs and small claims. And once we get permission, and Justice Gorman is a member of the Cadres Committee, when she says okay, that'll go up to the SJC for approval. So the Cadres Committee is aware, we're working on it. We're aware that there are backlogs. Anybody that would like to be a mediator and join the roster, we're happy to have all hands on deck. So
Yes,
thank you.
Barry, thank you very much. I appreciate that. Judge French, we are wrapping up. It is 11:30. Are there any alibis or last remarks that you wanted to provide before we all parted ways?
Nope, thanks again. I appreciate the invitation. I'll check on the ADK question as well as the closed captioning, and I'll let you know, Attorney Day, about that so you can distribute that information.
Chief Judge French, thank you very much for joining us, and we hope you'll be able to join us again.
Okay. Nice seeing everybody.
Bye. Thanks, Angela.